This AM 101. It is the membership puzzle and board of choice with Brian Polinsky. Just a reminder to please keep yourself muted, and you can ask questions in the chat along the way. We're anticipating there will be questions because it's a lot of material. So just add it to the chat, and we'll stop periodically and let Brian answer our questions. And everybody who registered will get a follow-up email from me with a link to the archive as well as all the meeting materials, because Brian has a great PowerPoint to share as well. So Brian, it's all you.
All right, thanks, Peggy. Good morning, everyone. So we're talking about a subject that I know people are often confused about, and you know what? I get it, because it can be kind of confusing. But the idea is that when we're talking about membership issues, we're actually talking about two separate kinds of membership. Because in California, we always have to treat association membership differently from MLS membership. I'm going to be primarily talking about the rules related to association membership, but I'm also very happy to answer questions about MLS membership as well. Now, I do have a PowerPoint that I'm going to be sharing and going through. One thing to keep in mind about this PowerPoint is it matches up very much with a legal Q&A that we published recently on this exact subject. So you can also find this information in the legal Q&A, but everyone who's attending will also have a copy of this PowerPoint if you'd rather use that instead. So I'm going to share my screen and we'll get started. So we're going to begin with basically the main idea behind association membership policy, and that is board of choice. Now, when we talk about board of choice, what does that actually mean? So that's what I'm going to address first. Board of choice is a policy that was adopted by NAR, and it gives members the ability to choose the local association they want to hold membership through, irrespective of the location of their office or firm. So there is no requirement now under NAR policy that you actually have to have an office within the geographical borders of the jurisdiction or territory of the association that you choose to join. So that is not something that you look at all when you're deciding whether or not to grant membership. Now, under previous NAR policy, persons who wanted to become Realtor members had to actually join the local association that served the area where their principal office was located before they could join other associations. That's no longer the rule. One key element of board of choice policy, universal access to services. And this means that realtors are actually entitled to purchase services from boards other than their primary board. And that can be without the necessity of even holding membership in those boards, and the actual service fees that are charged for those particular services can be determined by the individual boards. So this is kind of big picture about what I mean by board of choice. We're going to get into more of the details about how these rules are applied as we move forward. So next question, what is board of choice across state lines? And this is a question that comes up often, and it's something that I actually have addressed at an AE town hall because I know there's been some confusion on it. So board of choice across state lines, it's a further development of board of choice policy. It actually gives members the ability to join a local association, but as long as it's located across contiguous state lines. That contiguous part is actually important. Keep in mind that in California, there's actually only 3 states that are contiguous with us. In other words, that border California, and that would be Nevada, Arizona, or Oregon. But what the Board of Choice Across State Lines policy says is that a California real estate licensee could join a local association that is located in one of those states, Nevada or Arizona or Oregon, assuming that he or she otherwise meets the membership requirements of that association. The same is also true in reverse. A California real estate licensee could join a local California association if their primary association is in Nevada, Arizona, or Oregon. But this last bold bullet point here is important. This only applies for states contiguous to California. So if someone joins as primary in a state that is not contiguous, for example, let's say you have someone who is primary in Florida and they want to join a local association in California as a secondary member, this rule would not apply. Florida is not contiguous with California. So if someone wants to join a California association coming from Florida, they actually would need to have a designated realtor join the California association. So remember, this board of choice across state lines only applies to states contiguous to California. This is another very key question. Primary and secondary memberships, what are they? So under board of choice policy, a member is a primary member of the local association where he or she pays his or her C.A.R. and N.A.R. dues allocation and assessments, along with their local association dues. So the first association, the first local association that someone joins will usually be their primary association. Then a member is a secondary member of an association if he or she pays local dues only to that association, and that's because the member has paid their state and national allocations at the primary association. When we talk about primary and secondary memberships, we are really solely distinguishing the two based on the payment of dues. But when we're talking about the actual privileges and duties of membership, there is no distinction between the two. Secondary members actually have all of the same benefits, privileges, and obligations as primary members. So what does that mean? Number one, they have the right to vote in association elections. Number two, they have the right to hold office. Secondary members do have the right to hold any office in the local association. And I'll hear all the time from associations saying, you know what, we kind of want to restrict who can serve as an officer or director, and we want to make sure only primary members do that. Can't do that. According to N.A.R. policy, secondary members also have the right to hold office. And then also, secondary members are subject to both disciplinary and arbitration hearings at the association. So there is no rule saying that you have to file a disciplinary complaint against someone only at their primary association. You can file the disciplinary complaint against them at any association in which they're a member, whether a primary or a secondary member. Now, in order to become a secondary member of an association, a member must first establish a primary membership with an association. Also, since the C.A.R. and N.A.R. dues allocations are paid only once a year, a member is only going to have one primary association, but they can have multiple secondary associations, basically as many as they desire. All right, so those are kind of like the key ideas behind board of choice policy. Do we have any questions before I move on to the next section?
There are none in the chat right now.
Okay, I'm seeing that I got a direct message that was sent to me. So let me see what that says. Okay, that may be something to address later. Okay. So next thing I want to talk about, letters of good standing. What are they? Why do we have them? So first question to answer, what do we mean by the portability of membership records policy, and how does that actually apply to board of choice? So the portability of membership records is a policy adopted by N.A.R., and it gives associations the authority to request and consider certain membership information from other associations when they're evaluating an applicant's qualifications for membership. So a lot of the time, of course, someone who is applying to join at your association will have been a member at other local associations. And this is just saying, well, you should be able to get information about their membership status at those other associations. So the intent of the policy is to make certain membership information portable between the associations. That includes records of prior violations of the Code of Ethics, any unpaid arbitration awards, and any unpaid financial obligations to the association or the association's MLS. This is all information that your association should know before deciding whether to take on this person as a new member. This policy was adopted in response to concerns that Board of Choice would allow members to resign membership in one association and join another association to avoid code of ethics and other membership obligations. And that's a reasonable fear. Because just think about the fact, let's say that someone files an ethics complaint against a realtor. And that realtor says, well, I don't want to deal with this. I'm just going to resign from this association and join another one. And that second association will never know that someone filed against me. Well, we don't want people to be able to avoid being subject to the code of ethics and the disciplinary procedure. So the portability of membership records makes sure that if someone is leaving an association, we know about what happened to that person at that other association. So next question, what is a letter of good standing? Now, according to language that NAR requires all associations to include in their bylaws, the term good standing means a member satisfies all the obligations of realtor members, is current with all financial and disciplinary obligations to the association and MLS, has completed any new member requirements, and complies with NAR's trademark rules. So whenever you hear the words member in good standing, this is the definition that NAR applies to it. All of these things must be true in order to say that a member is in good standing. So I know a lot of times in the past, people thought a member in good standing just meant that the person has paid all of their dues, but it's more than that. You have to satisfy all of your financial obligations, meaning if you were subject to any discipline and you had to pay a fine, then you must pay that fine in order to be satisfying all of your obligations to the association. And of course, completing new member requirements, complying with trademark rules. All of those things have to be in effect. Now, if an association requests information about whether a current or previous member of another association is in good standing, the association receiving the request must provide the information expeditiously. So typically, the association receiving the request will fill out a letter of good standing to provide all the relevant information to the requesting association. And C.A.R. actually provides a sample letter of good standing form that local associations can use. It's available at this link. Why don't we take a look at it right now? All right, I clicked on the link. It will be open in a moment. All right, so hopefully everyone can see that. This is the sample letter of good standing that C.A.R. publishes and that we recommend that you use. So it includes all of the information that you would need to provide to the association requesting information. So at the top, we have member's name, member's number, and then in bold, we kind of have the bottom line. Either the member is or is not a member in good standing of your association. Then we have questions related to discipline. So make sure that we answer all of those questions. Financial obligations, is this person up to date on all of their financial obligations and dues, both for C.A.R. and NAR and for the local association and for the MLS. And then we ask whether the member has fulfilled any of their orientation requirements. So all of this information combined is necessary to determine, and this is pursuant to NAR's definition, whether someone is in good standing. So this is the appropriate form to use when someone asks you for this letter of good standing. Now,
Brian,
besides, yes.
Before you move on, we have two questions about letters of good standing.
Sure.
The first one is from Sylvia, and it's her understanding that if someone has unpaid dues or ethics issues, you still have to allow them access to MLS if they apply.
Right. So in this section, we're talking about association membership. As I said, when you're talking about MLS membership, the rules are completely different. So the reason that the rules are different for MLS membership is we're very concerned about antitrust issues, and we don't want to take any actions that would make it impossible for someone to be able to act as a real estate agent in California. And so, and also when we're talking about MLS membership, issues related to association membership have to be siloed off. So When you look at the qualifications for MLS membership, it's basically that they have to have an active, valid license. They have to be licensed with an MLS participant. And there are a couple of other things, but it's nothing related to the Code of Ethics, because the Code of Ethics is related to association membership. It has no relation at all to MLS membership. So you don't worry about Code of Ethics issues when you're deciding whether or not to grant MLS membership. When you're talking about unpaid dues, if it's association dues, again, that is irrelevant when it comes to MLS. But if it's unpaid MLS dues at a different MLS, then that can be taken into consideration when you're deciding whether to grant MLS membership. But yeah, generally the requirements for joining the MLS are significantly less stringent than they are for joining the association. Any other questions there?
You know, the other one's kind of related to that, so no.
Oh, okay.
You covered it. Thanks.
Yeah, I know this is often an area of confusion for people, because a lot of what I'm talking about today has to do with association membership. MLS membership is treated separately. Okay. Okay, yeah, I haven't talked about this slide yet. All right. So there are actually other methods that local associations can use to find information out about an applicant. I wouldn't necessarily say that you should do this solely in substitute for asking for a letter of good standing, but you can also do this in addition to it. So C.A.R. has a statewide database called Ethics Check, and that contains information about all the disciplinary and arbitration cases filed at associations in California. This database is restricted to certain local associations and C.A.R. staff, and it can only be used for certain permitted purposes. Local association staff can obtain access to Ethics Check to generate a report on any person with the DRE license number. So you can do a search in Ethics Check, and there will be a report that pops up showing whether the person that you're searching for has any other violations or any pending cases throughout the state of California. And this is information that you can use and provide to your membership committee when deciding whether to accept someone's application. All right, any other questions about letters of good standing?
There's a couple that just popped up. Should we be asking for the letter of good standing annually for secondary members?
No, this only applies when someone is applying to the association for the first time. When someone is a secondary member, if they have, for example, a disciplinary hearing going on at another association, that association will be handling it. Now, if that association is to suspend or expel that person from membership, we actually have a procedure where that association reports it to C.A.R. and a panel of C.A.R. directors decides whether that suspension or expulsion will be applied statewide. If that happens, we will let all the associations know about it. It's not something that happens particularly often, but no, there's no need to ask for a letter of good standing every single year.
And I'm going to have Donna unmute herself to ask her question because it's long.
Okay, Brian, so this kind of came up where the question came up with if the association marks their letter of good standing with a yes, they are in good standing. But in the area under MLS obligation that they mark yes, that they owe for MLS, perhaps that amount is that current month's MLS fees. So would you go by the fact that they owe MLS fees and you wouldn't process it, or would you go by the fact that it's marked yes, that they are in good standing?
I think that associations may be filling that out wrong. If the MLS fees aren't actually yet due, then I don't think it's correct to say that they actually owe that money or, are not in good standing at that point. So I think if maybe that's like a confusing way that the form is filled out. But if they're not like past due on those amounts, then I wouldn't say they're not in good standing. Is that what's happening here?
I think that it's because it's not clear. I mean,
Okay.
they could only, they're looking in their accounts receivable and say, oh yeah, Brian has a past due balance, but it could be that they just billed that for that month.
Well, that's different than saying past due, right? Because if you build it, it may not be due yet. Yeah.
Or perhaps maybe it's into the next month, but they're not seriously delinquent. And I would be thinking you would go by more of the fact that the letter would state whether they are in good standing or aren't in good standing.
Well, but then that's a different question, because if they actually are past due on any fees, then they're probably not in good standing, according to NAR's definition. So yeah, I think that's the question, whether it's just the fact that they were billed and haven't paid yet, but not past due, or whether it actually is past due. I do think that makes a difference. All right. Do we want to move on to the next section now?
Ready.
All right. So next thing I want to talk about, realtor status. Who can actually join the association as a realtor? So first question, does NAR policy or the law require real estate licensees to join a local association of realtors? And the answer to that, of course, is no. Realtor organizations are private trade associations, and deciding to become a member is a matter of personal choice. So no one is ever forced to be a realtor. Now, if a firm wants to become a realtor firm, do the partners or officers of the firm have to individually hold realtor membership? And the answer to that is yes. And this is according to the local bylaws of every association. So under NAR policy and the C.A.R. model bylaws, each partner or officer of the firm has to hold realtor membership individually in order for the firm to become a realtor firm. However, that doesn't mean the agents affiliated with the firm must also join a local association. But if they don't, then there are certain consequences, which we'll talk about. Can a firm require its agents to join a local association as a condition of being employed or affiliated with the firm? And the answer is yes, a firm is free to do that. Some realtor firms have policies that do require their agents to join a local AOR as a condition of being employed by or affiliated with the firm. And that is the firm's prerogative to do that. It's usually done to encourage networking in the local real estate community or for other reasons, but where firms have adopted this policy, sometimes there's a mistaken perception that arises that it's actually the local association or C.A.R. or NAR that's requiring the agents to join, but that's not the case. It's the firm that's making that decision. So next question, can a salesperson join an association as a realtor member if they are not employed by or affiliated with a member firm? And the answer to that question is no. In order to be eligible for realtor membership, licensees who are not principals of a firm must be associated with a realtor firm, either as an employee or an independent contractor. So this involves someone who is not a broker or principal or corporate officer and would not be eligible to become a designated realtor for the firm. If they want to be a realtor member, they have to be employed by or affiliated with someone who is a realtor member. All right, before we move on, I'm seeing a question in chat. Can we require a board of choice agent? Is that what we mean by BOC? To have a responsible broker who has established either primary or secondary membership. I think I just addressed that question in the last slide, unless I'm misunderstanding. Yeah. I'm not sure I quite understand the question here.
Brian?
Yes.
Kathy Hinman. I know
Okay.
this has come up many times, and that is that if you have an agent who's a member elsewhere, like a neighboring association, and their broker is a member there but not here, and they want to belong to your local association, as whether it's a primary or secondary, it is allowed because their broker is a broker board of choice with the neighboring association. They don't have to be a broker member of our association. You would want.
So that's true, but
you'd have to have a letter.
Yeah,
you'd have to have a letter, right?
Yeah. I'm sorry, you have to have a letter from whom?
Well, you would have either a letter from your broker saying that they are designating you as the designated realtor of this local association. Or if it's secondary, you've told us that as long as they have a membership elsewhere with their broker in California or contiguous, that they can become a secondary member at the local without their broker being a member of the local.
Yeah, that's correct for secondary. When we're talking about primary, that person would actually have to meet the definition of a designated realtor, which we're going
Correct.
to talk about in the next section.
Okay, great.
All right, anyone else? Cindy, was I able to answer your question? I'm not sure I understood your question. All right, okay, I did. Let's move on to the next section. And we'll talk now about designated realtor. What does that mean? Who's eligible to be a designated realtor? All of that. This is a really important concept when we're talking about the membership puzzle. So what is a designated realtor? So pursuant to NAR policy, each firm has to designate in writing one designated realtor member who is responsible for the conduct of individuals affiliated with the firm and accountable to the association for all the duties and obligations of association membership. That includes binding the firm in arbitration, being responsible for disciplinary hearings at the local association, and being accountable for the payment of membership dues under the variable dues formula. So anyone who becomes the designated realtor for a firm has to be aware that they can actually be held personally liable for arbitration awards against the firm or its agents, and that they can be disciplined for the unethical acts of the firm or its agents. So it's not a status to be taken on lightly. All of those things will apply if you become a DR for the firm at the local. But nothing prevents the firm and the designated realtor from reaching an agreement as to the ultimate responsibility for the arbitration award. So they could have an internal contract saying that, okay, even though you're the DR and you could be held personally liable, that the firm will indemnify you for any potential damages that you may have from that. The real estate firm determines who the designated realtor shall be, and local associations do not make that decision, and they shouldn't be involved in that process. However, associations do have the right to reject a proposed designated realtor if the individual doesn't meet the qualifications for DRs set forth in the association's bylaws. So as Kathy was just talking about, a firm wants to designate someone as the DR for the firm. Well, you don't necessarily grant that. You do have to check to make sure that the person meets the criteria. So let's talk about we'll talk about that in a moment. The next slide is, does the firm's designated realtor need to be the same person as the firm's responsible broker with the Department of Real Estate? And the answer to that is no. The designated realtor has to be the sole proprietor or a partner, corporate officer, or office manager acting on behalf of the firm's principals. So that is the definition of a designated realtor. So anyone who is a sole proprietor, partner, corporate officer, or office manager acting on behalf of the firm's principals. And they will have the authority to bind the firm in arbitrations and meet all of the other qualifications for realtor membership. So you'll note here, there's no requirement that the designated realtor must be the same person as the responsible broker. In fact, there is no requirement that the designated realtor even hold a broker's license. Important point. The designated realtor can be licensed as either a broker or a salesperson. It's possible you could have a salesperson who's an office manager, for example, or even a corporate officer. So keep that in mind. A broker's license is not a requirement to be a DR. Now, also keep in mind that many firms do choose the responsible broker listed with DRE to be the designated realtor. They just don't have to do that. They're not required to do that under NAR policy. So next question, can an agent join an association as a secondary member if the agent's firm does not have a designated realtor at the association? And the answer to that is yes. So unlike with primary membership, an agent may hold secondary membership at any association without the agent's firm having a designated realtor at that association. But remember, this ties back to board of choice and board of choice across state lines. So not necessarily any association, it has to be an association in California or a state contiguous to California. However, before an agent can join an association as a secondary member, he or she must first establish a primary membership at a different local association. So that is step one. Once they have primary membership at an association in California or a contiguous state, then they can join your association as a secondary member. Next question, can a firm have more than one designated realtor? The answer to that is yes, but only one designated realtor per association. So for example, there are some firms with branch offices that desire to join more than one association. And in these situations, the firm can authorize the branch office manager for each office to be a designated realtor for the association that the branch office wishes to join. So the result here is that you can have a firm with several designated realtors, but only one designated realtor at each association. Now, of course, if the firm prefers to have one DR for all association memberships, they can do that. And many firms do it that way. They'll have a DR who's primary at one association and then just becomes secondary at all of the other associations where the firm's licensees belong. And so that's another way to do it. Or the firm can assign different people to be a DR at each of those local associations. So each of those are potential options here.
Brian, Dawn has
Yes.
a question in the chat asking how you define an office manager.
Yeah, so NAR doesn't really provide a good definition for an office manager. Basically, the way that I see it, it would be someone who is in charge of supervising a particular office branch of the firm. But yeah, there is no formal definition of an office manager. What they do say is it has to be someone who is acting on behalf of the firm's principals. So the firm's principals must have designated that person to have some authority over the particular office. So I know that might not be the most satisfying answer, but that's the best that I have given what we say in the bylaws. All right. Anything else before we move on to the next section?
That's all that's in the chat right now.
All right. So next subject to talk about, oh, I am seeing one more here. If the firm assigns multiple DRs, how does that impact how offices are created if the DR is different at each local board? So are we talking about through the membership system? Because my understanding is that you should be able to do it that way through the membership system. But I'm not someone who has a lot of experience using the M1 membership system, so I may not be the best person to answer that. I don't know if you have any insight into that, Peggy, or anyone else here.
I do not.
Okay. But yeah, that would really be more of a question for Kiesman, who knows a lot more about how M1 works. But yeah, there should be a way to do it that way. All right. Association and MLS Services. So under Board of Choice, services from other associations are available irrespective of where a member seeking those services holds his or her membership. That includes services such as sold or comparative data and access to lockbox systems that are provided by the association. Now, this is only subject to a member's agreement to abide by any related rules and regulations of the association from which a service is being sought. And the actual fees that are charged by the association are determined individually by each association. Keep in mind that neither Board of Choice nor any other NAR policy will govern the prices that associations set for these association and MLS services. You just have to make sure that they're available, and that's pursuant to Board of Choice policy. However, we do advise associations to seek the advice of counsel when making decisions regarding the pricing of services, especially services that are related to the MLS. Now, a little bit more about MLS Access. So based on several California court decisions, real estate brokers and agents have the right to participate in or subscribe to the MLS, regardless of whether they are members of any association of realtors. Key point in California, you have to keep this in mind, because even as of a few years ago, I think I've gotten questions from people saying, you know, an association told me that I couldn't join the MLS without first joining their association as a realtor member. And in California, you cannot have that policy. because that would be a violation of antitrust law in the state. So people can join the MLS separately from the association, and they do have the right to do that. However, an MLS may deny access to real estate salespersons that are not affiliated with a broker participant of the MLS. So when we're talking about MLS membership, the key thing for MLS membership is that if you have a salesperson that wants to join the MLS, they can't do that unless they have a broker participant that is also a member of the MLS. That is really the number one thing to remember when you're talking about MLS membership. And I think when I was talking about secondary membership, I don't know, probably not this time, but other times, people got a little confused about that. And they're saying someone wants to join the MLS as a secondary member. No, no, no. The concept of secondary membership doesn't apply at all to MLSs. It only applies to association membership. If someone wants to join your MLS, they are either joining as a participant or a subscriber. We don't talk about primary and secondary membership when we talk about the MLS. They can be a participant if they have a broker's license, and they can be a subscriber if they have a salesperson's license. But to be a subscriber, you have to be affiliated with someone who's a participant. So that is really the key when we talk about MLS membership. An MLS may bill realtor firms from other associations in the same manner as it bills its own members for MLS services. So for example, if fees are based on the number of real estate licensees in the office, the same policy can be applied to the realtor firms from other associations. So now a little about discounts and solicitations. Now, sometimes associations will offer a waiver of application fees or local dues, or they'll offer a free trial membership to encourage real estate licensees to join the association. Engaging in these practices is a matter of local discretion. That's not governed by NAR policy, so you can do it if you want to. It's recommended that if an association wants to engage in those practices, that these incentives should be offered to all real estate licensees on the same terms and conditions. So what you cannot do is discount C.A.R. or NAR allocations or assessments. That would not be permitted. Neither NAR policy nor the law restrict the ability of local associations to advertise and market their services, including soliciting members of other associations. Not saying you should do that, just saying that if an association does that, it's not a violation of NAR policy, and it's not a violation of the law in any way to solicit members of other associations. However, local associations can be liable if they engage in false or misleading advertising claims about either itself or about another association. So if you solicit, just be careful to make sure that your solicitations are accurate. All right, any other questions here before I move on?
We have one, but I'm not sure I understand it. Somebody needs clarification regarding primary members with their brokers without a DR. Oh, she's going to unmute.
Okay, yeah.
Hi, Brian. Sorry, it's Alicia from SMVR. So it was my understanding that in order for a primary member to have membership here at our association, but their broker was not a member, that their broker needed to join the local association as a secondary member or have that DR letter on file designating an individual being responsible. Am I unclear in that? Because
no, I think you're absolutely right. That's consistent with everything that we've been talking about. So in order to join an association as a primary member, you either have to be licensed with someone who is a designated realtor at the association, and they could be a secondary member as a DR, or you yourself would have to be the DR.
Okay, so in order for the primary to be with us, their broker has to have secondary membership with us if they do not have a DR.
Correct.
Thank you.
And to be clear, it doesn't necessarily have to be their broker. It just has to be someone from the firm. That's the DR. All right, anyone else? All right, so the last thing I have in terms of my PowerPoint, most common questions that come from members about membership issues. So let's go through these. A lot of these are kind of reviewing things that we've already talked about, but definitely worth reiterating here. Does a broker have to join each local association that one of the broker's affiliated licensees wishes to join? The answer to that is no, but however, the broker's firm must have a designated realtor member for each association that an affiliated licensee wants to join as a primary member. So I think this really just answers the question that Alicia was just asking about before. Next question, if a salesperson switches to a new broker and the new broker is not a member of the salesperson's local association, does the new broker have to join the salesperson's association as a secondary member? And the answer to that one is the broker is not required to join, but the broker's firm must have a designated realtor member at the salesperson's primary association. And the designated realtor can join the salesperson's association as a secondary member. That's always an option. Or they can assign potentially that salesperson to be the DR. But remember, they have to meet the criteria to actually be a DR, which would mean they have to be a principal, sole proprietor, corporate officer, or branch office manager. Next question, can a salesperson join an association as a secondary member, even if their firm does not have a designated realtor member at that association? The answer, of course, is yes. So that's the difference between primary and secondary membership. Secondary membership, you can join without your broker being a designated realtor at that firm, at that association. Next question, is realtor membership required to join an MLS? The answer to that is no. An active broker or salesperson license, however, is required to join an MLS, but realtor membership is not. Next question, may a salesperson join an MLS without their broker also joining? Generally, no. According to the C.A.R. model MLS rules, real estate salespeople are only eligible for MLS subscriber status. And to be an MLS subscriber, the licensee must be employed by or affiliated as an independent contractor with a broker participant of the MLS. So remember, this is the question that when people are asking about MLS membership, this is the key. To join the MLS, you have to have a broker participant at the MLS. And then the last question, this is one we haven't talked about yet, about LIFROs. Can a limited function referral only licensee join an MLS? And the answer to that is no. And that's based on the definition of a LIFRO in the model local bylaws. A LIFRO is defined as a licensee who is solely engaged in referring clients and customers, is not engaged in activity requiring a real estate license. In other words, buying, selling, exchanging, renting, or leasing, managing, counseling, appraising for others for compensation, building, developing, or subdividing real estate, and is not a participant or subscriber in an MLS. So by definition, a LIFRO is not allowed to be a participant or subscriber in an MLS. Now, you may note here, it doesn't say they can't join an MLS in any capacity. There's also another MLS status called clerical user status. And when you're a clerical user, you are not a participant or subscriber in the MLS. So that is a different sort of status, and that would be allowed for a LIFRO, but they cannot be a participant or subscriber. Thus, any licensee whom a broker certifies at a local association as a LIFRO cannot join an MLS as a participant or subscriber. And if an association discovers a LIFRO has joined the MLS as a participant or subscriber, the association can change the LIFRO status to a non-member salesperson, and that would mean they can charge the broker pursuant to the variable dues formula, office size formula. So that should cover the LIFRO issue. It's different when you're a participant or subscriber in the MLS. That is different than clerical user status. So important to make that distinction. All right, that's all I have in terms of prepared material, but I'm happy to answer any other questions that anyone may have right
now. Jessica would like to know if LIFROs get charged as an NMSP.
They don't. The idea behind the LIFRO status is that it exempts that particular licensee from non-member salesperson fees that the designated realtor would have to pay. So everyone that the designated realtor certifies as a LIFRO is not going to be included in calculating the dues that the designated realtor would owe to the association.
And then Dawn has a question. Can a LIFRO join under one brokerage, but join as a clerical user under another? So to be clear, LIFROs do not join the association.
What happens is when a LIFRO is certified, the designated realtor is specifically saying that this person is not joining the association. So when someone is a clerical user, they are joining the MLS and not the association. The rules for whether someone can be a clerical user state that someone has to be actually employed by or either employed or a contractor with. I'm not sure I'm getting the exact language here, but something like that. Employed by or affiliated with a participant or subscriber of the MLS. So in order to actually join as a clerical user, they would have to demonstrate that they're actually employed by that person. So it's kind of an interesting question as whether someone would be licensed with a broker, but then be employed by a different broker. It's a little unlikely. So I think that's something that you would have to look into more if you ever, get into that situation. But yeah, generally it wouldn't really make sense for someone to be licensed with a particular broker, but then say, oh, I'm going to be a clerical user with an entirely different broker. It could happen. It could happen. Yeah. So I'm not necessarily saying that that is prohibited, but you just have to look into it more and make sure that they're actually employed by or working for that broker or participant or subscriber that they're registering for as a clerical user with.
Thanks, Brian. And then Leslie wants to know if appraisers are eligible to join as an affiliate, or are they required to join as realtors?
I believe that appraisers are eligible to be realtor members. I'd have to look at the bylaws on that, but I think that's the case. Let me see if I can find that right now. But yeah, I think I remember there's language in the bylaws that say appraisers qualify to be realtor members. Let me see. Yes, so realtor members, whether primary or secondary other than principals, shall maintain a current valid California real estate broker or salesperson license or a California real estate appraisal certification or license. So that means that an appraiser is qualified to be a realtor member. And anyone who is qualified to be a realtor member doesn't qualify for affiliate member status.
That is all I see in the chat right now. If anybody else has any questions, you're more than welcome to unmute and ask. I know this is a lot to digest. Doesn't look like it. Okay, well, everybody, thank you for attending. Brian, thank you very much for all of this information. It was great, and I will package it up and send it out in a follow-up email tomorrow. So thank you, everybody, for attending. Brian, again, thank you for presenting.
Of course, you're welcome. Thanks, everyone.